Today we will talk about what makes an agreement abusive. The law is clear. An agreement is abusive when it doesn't meet a real need of the company, is made by the majority for their own benefit, and unfairly harms the other partners. This means when there isn't enough reason for it, and the minority is clearly hurt. On the other hand, abuse of right happens when an action that seems correct actually hides going too far, which the law doesn't allow. Legal rulings require three things to prove it. First, using a right that is legally correct on the surface. Second, causing harm to something not protected by law. And third, the harm being wrong or against society, either by wanting to cause harm or by using the right in an unusual way. We've seen clear examples, from meeting calls that, while formally correct, change usual practice to exclude partners, to agreements that carefully adjust profit sharing to prevent minority partners from leaving, or capital increases that are formally correct, but unfairly reduce the minority's share. In these cases, the agreement is invalid precisely because making it is an abuse of right. The complexity of this issue leads us to ask important questions, all of which have been discussed in legal rulings. First, when is an agreement abusive? Supreme Court ruling number 3, 2023, has made the definition of abusive agreements broader. Now, it's not just about harming the company's interest, but also when agreements are made without a good reason for the company, for the majority's own benefit, and unfairly hurt the other partners. Second, can an agreement not to share profits be seen as abusive if the majority partner thinks it's right because of uncertainty about their main client? The answer depends on how strong the reason is. Third, is it an abuse by the majority if during a meeting, all proposals from the minority were rejected by the majority partners without any reason or explanation, even when the minority asked for one? Legal rulings state that simply forcing a vote isn't abusive on its own. Fourth, is an agreement about how much an administrator is paid considered abusive if it seems too high? Judges can check if the payment is abusive without setting a specific amount. Fifth, can an administrator's pay, if they are also a majority partner, be seen as abusive if it's much higher than what employees get? This is something judges often look at. Finding and stopping abuse by the majority and abuse of right are very important for fairness and good management in companies. Understanding its limits and the legal tools to fight it is key to protecting all partners. We hope this summary was helpful and invite you to read more about this legal analysis. In this fourth video of the Meeting Time series, we looked at abusive agreements made by the majority. In the previous video of the series, we talked about the right to information. And in the next video, we will finish this series by discussing how to challenge a meeting. We hope these videos are useful to you. Send your questions and challenge our AI Atenea. Complex questions, expert answers. More information at ilpabogados.com.